We originally considered going through a number of the questions which were distributed to you, and last week we met during the evening, and over a bottle or two of wine it occurred to us that it might be of more benefit, given the caliber of this panel, if we called on each of them individually for a few remarks along the kind of topic that we're talking about this morning, with some reference to the practical experience that each of them have had. We hope we didn't mislead you by saying we were going to answer the questions that have been distributed, but it was our feeling, and I hope it's a correct one, that the approach we're going to take will be of more practical benefit to you. My function here is merely to be that of trying to keep a lid of some kind on this rather outgoing group of superb advocates, and that's what I'll try to do as we proceed along. So you have some idea of where we're going, and that's always a useful idea. Ken Howie is going to start off with some comments generally on the choice of forum, jurisdiction of Ontario courts, and the question of the convenient forum as it has been considered. He's then going to give us some of his comments dealing with a couple of interesting and important cases in which he's been involved, particularly the Air Canada crash that you've all heard about, and the case involving the thalidomide experience in which Ken was deeply involved. Earl is then going to discuss questions of jurisdiction, considering questions of how and why, with particular reference to matters such as punitive damages, why jurisdiction should be chosen and where, and a Pinto case in which he was recently involved and with which I'm sure most of you are familiar. Buddy Wunder is then going to talk to us about the question of forum shopping, as it's been referred to, and Buddy is known as one of the best shoppers around in that area, I might tell you. He's going to give his experience as to specific considerations with knowledge of good and bad areas which should be considered in the United States particularly, and talk to us about fee situations and problems which can occur in handling these cases with lawyers in other jurisdictions. Time permitting, we then want to have a general discussion on some of the downside risks which might be considered in the forum choice, such as the contingent fee, insurance limit problems, probabilities or possibilities of defense verdicts in other jurisdictions, and the probable range of verdicts. If we have time, we'll consider again specific problems of referral of cases, and hopefully some comments on class actions, in which Earl Cherniak has been involved, and we'll have a few comments on those as they lead to commercial disputes. I'll say no more and call upon Ken Howie to start off.
Thank you, Mr. Chairman. The choice of forum in respect of personal injury or fatal accident cases, I talk about those because I have little experience in my wide commercial practice. I want to talk to you briefly about that side. The choice of forum must be made, and the first point I think to be made, must be made at a stage when there is no concern about the intervention of any limitation period. Let's assume the case of a youngster, a young plaintiff. Let's assume he's 19 or 20 years of age, so he's not an infant in Ontario, is seriously injured in a motor vehicle accident in British Columbia. The plaintiff, it turns out, has gone to Vancouver from his home in Ontario, he's single, for a year to work a bit, to see the country, before intending to return to Ontario to resume his university education. After his initial hospitalization in British Columbia, he's rapidly brought back to Ontario, where he's hospitalized for a long period, ultimately suffers a leg amputation, and continues on ultimately with his schooling and remains in Ontario thereafter. The proposed defendant is a British Columbia resident, and of course the accident happens there. Now, under Section 25(1)(h) of the rules, the usual conflict rules would suggest that the plaintiff can only sue in British Columbia because the Ontario court probably will not take jurisdiction. I think we're all familiar with the old rule, broadly stated, was that in a tort situation you had to sue either where the accident happened or where the defendant resided. And to some extent, I think that was governed by the wording of Section 25(1)H. It's worthwhile if I just read it to you. It's short. It says, a party to an action or proceeding may be served out of Ontario as provided by Rule 26, where the action or proceeding as against that party consists of a claim or claims in respect of damage sustained in Ontario arising from a tort or breach of contract committed elsewhere. Now, the issue, at least the interpretation that seems to have been made for years and years and years, was that the word damage equaled injury. That is, read it where the action consists of a claim or claims in respect of injury sustained in Ontario arising from a tort or breach of contract committed elsewhere. Well, that, if you interpret the section that way, since the injury occurred, quote, injury occurred in British Columbia, the Ontario courts would not take jurisdiction. There are two recent cases, one of which was referred to by Bill Graham, which you should know about. The first is Vile, V-I-L-E versus Van Went, which is reported in 26 Ontario Report 2nd at page 513. The head note of that case will very quickly give you the answer. The plaintiff was injured in Quebec as a result of an accident which occurred during the unloading of a concrete statue from a truck in Quebec. Following the accident, the plaintiff was hospitalized in Ontario. The plaintiff's claim, that I'm reading from the head note, that the same occurrence gave him a right of action against all of the defendants. I'm sorry, I don't need to read that. Hang on a minute. Although the accident and injury occurred in Quebec as a result of a tort committed in Quebec, the plaintiff had suffered damage in Ontario when he returned to hospital for 6 months and to his home following the accident. He had incurred medical expenses and undergone pain and suffering in Ontario, had been deprived of the amenities of life, and suffered loss of wages and business profits in Ontario, all as a result of the injury. Such damages were sustained in Ontario, even though the accident and the initial damage occurred in Quebec. That was a decision of the Divisional Court. The second case, I'll just mention it because the facts are similar, is Poirier, P-O-I-R-I-E-R versus Williston, which is reported in 1980. It's 29 Ontario Reports 2nd at page 303. Again, a decision of the Divisional Court, and quickly, in this case, the plaintiff is a resident of metropolitan Toronto. In August 1978, he was injured in an accident which occurred in New Brunswick. The defendant resided in New Brunswick. Again, same decision. The court felt or held that the Ontario courts had jurisdiction. However, it's worthwhile to read this, and I'm quoting from the judgment. In this case, a resident of Ontario has suffered grievous damages. The damages include pain, suffering, disability, loss of ability to earn an income. They have been and continue to be suffered in Ontario, thus it was quite proper and just to bring the action within this province. There still remains the question of whether Ontario will be the convenient forum for the trial and disposition of the action. We are not prepared to deal with that issue. There's been no material filed either on behalf of the plaintiff or the defendant with regard to that aspect of the situation. Finishing it up, in 31 Ontario Reports, 2nd edition at page 320, the Court of Appeal affirmed that judgment of the Divisional Court, so that clearly is the law of Ontario. Well, if you can establish then that the damages have been incurred as opposed to the injury in Ontario, our courts apparently will assume that they have jurisdiction. Be careful, however, because the second part is that merely because the Ontario court has decided to take jurisdiction, or you decide the court will take jurisdiction, that doesn't necessarily mean that you're going to be able to pursue the lawsuit in Ontario. In other words, the issue of forum conveniens remains to be determined. Now, even though the court decides it has jurisdiction, in the case I cited to you, it may decide that the convenient forum is British Columbia. Now, again, I started out by saying to you be extremely careful with respect to the intervention of the limitation periods, where you're dealing with a relatively short limitation period, as we find under our Highway Traffic Acts and under the acts in British Columbia, for example. The only way to protect your client in that situation is to ensure that you commence action in both jurisdictions well within the limitation period, and then attempt to sort out the issue of whether or not the Ontario court wants or will take jurisdiction, and whether or not the forum conveniens is going to be Ontario, or whether it's going to be British Columbia. Well, what determines forum conveniens? Later speakers today, and some of my more academic and learned colleagues to my right, will deal with some aspects of this. Broadly speaking, the presence of witnesses required to determine the major issues in the case, that is, in the one I cited, liability and damages, the likelihood of delays that may arise in one jurisdiction or the other, difficulties of proof that may exist in one jurisdiction or the other, differences in the law and the application of the laws of the other jurisdictions, the issue of damages, that is, whether or not the damages are likely to be appropriate in the other jurisdiction, and other matters will tend to govern that decision. Again, it is in effect the balance of convenience or the preponderance of convenience which will govern the decision by the Ontario court as to whether or not the convenient forum is Ontario or British Columbia. Well, take our particular case in British Columbia. If there was a very serious contest with respect to liability and a large number of witnesses in British Columbia, let's assume, in fact, the case I'm thinking about, there is a very serious contest on liability, and a number of witnesses responsible for that, assume that the medical issue is not seriously in dispute. While the injuries are serious and the damages are severe, there isn't a serious medical issue. It may very well be in that situation that the Ontario court would decide that the British Columbia court was the convenient forum because of all the witnesses who would be in British Columbia because of the liability situation. Again, reverse it. If it were a situation where there was no doubt about liability and there were scads of witnesses in Ontario with respect to the issue of damages, one would have thought it more likely that the Ontario court in that case would take jurisdiction. Well, it may be interesting for a moment to deal with a real case, and that was the Air Canada international flight in June of 1978 that resulted in the aircraft, as you may recall, running off the end of the runway at Malton and causing injury and death to 96 persons on the plane. Very quickly after that accident happened, a committee was formed of lawyers who had been retained by most of the plaintiffs, and they met, as they had after the San Therese crash in 1967, to work out some strategy to operate against Air Canada. Except that the facts from the very beginning indicated probably pilot error and possibly negligence by the manufacturer. The manufacturer was Douglas Aircraft of California. Immediately, counsel were faced with the problem of whether or not they should consider bringing action in Ontario or whether they should bring it in California or in both. The committee consulted with Jerry Stearns, who's a tremendously competent and highly experienced air crash lawyer in San Francisco, who had been successful in persuading the courts of California to accept jurisdiction almost in every case in which a Douglas aircraft was involved, no matter where the accident had happened anywhere in the world. He felt that probably the California courts would take jurisdiction because, of course, the manufacturer was resident in California, and to the extent that there was a defect in the manufacture of the plane, obviously that was a matter for which the California courts would take jurisdiction. Counsel were satisfied that the assessments would, on average, be double what they were in Ontario, and in that connection I have with me, if any of you were ever interested in seeing it, an affidavit of Professor Fleming of California. Now that's Fleming on torts. just so you'll understand who he was, John Fleming. And in that affidavit, he compares the assessments of damages in Ontario and in California. I think it's fair to say that he is astounded and upset by the level of damages that exist in Ontario compared to what they are in California. That affidavit was filed in the course of the proceedings to persuade the California court to take jurisdiction to demonstrate how badly compensated the plaintiffs would be if they were forced to pursue their lawsuits against Air Canada, their national airline in their own country, with their own courts. Remember, in this case, that the plaintiffs were all, with one or two exceptions, residents of Canada, and with a very few further exceptions, they were residents of Ontario. The arrangements with respecting contingency fees were discussed, and it's a matter just to tell you that that obviously had to be done. We'll leave it to Buddy Wunder to talk about this, since he is the world's leading expert on any kind of fees, including contingency fees. The committee, as individual lawyers, obviously had the task of advising their clients as to what should be done. Should we sue in California? Should we sue in Ontario? Again, I want to leave the details of this to Earl Cherniak because he's more experienced with it and he's better prepared than I am with respect to this particular problem. But what happened was, using the threat of going to California, that is the whole group of lawyers, i.e. all the plaintiffs going to California, very extensive negotiations took place between Air Canada lawyers and the representative of the committee. Eventually, as a result of the negotiations, Air Canada, in writing, offered to each individual plaintiff, through his lawyer, that if that plaintiff brought his action in Ontario and refrained from bringing action in California or elsewhere, one, Air Canada formally admitted liability. Two, the damages would be considered, quote, on a generous basis, end of quote, by Air Canada. And three, Air Canada stipulated in writing that the then recent principle of the trilogy of cases, that non-economic general damages were to be limited to $100,000, would be waived by Air Canada. In other words, there would be no upper limit on non-economic general damages. As a matter of interest, what I wanted them to do, what I thought I'd persuade them to do, was to agree that the non-economic general damages should be double. That is, whatever the court arrived at, Air Canada would agree to double it. They were prepared to do it except for one reason. Can you think why? Precedent. They wouldn't do it because of precedent, so that this was the compromise that was eventually worked out. The point is that in terms of the availability of two jurisdictions, the power of the possibility of the plaintiffs going to California and obtaining a California-style assessment of damages was never more clearly demonstrated. As happened, the result of the tactic was that the lawyers promptly disbanded because they knew that they could now handle the matter themselves and they didn't need a committee anymore. Each lawyer, however, was faced with a choice of forum, and in the case of this crash with a 6-year limitation period, there was lots of time. Many of the lawyers recommended to their clients that they should proceed to California, and they did. Litigation ensued in California, directed to the issue of jurisdiction. In the final analysis, the California courts refused to take jurisdiction, largely on the basis of forum conveniens, although I also think it had a good deal to do with Air Canada's admission of liability. It had to do with the absence of any certainty or uncertainty as to whether or not there'd be any recovery by the plaintiffs because Air Canada admitted liability. The fact that most of the persons claiming were Ontario residents anyway, I suspect they were not as shocked about the assessment of damages as they were, for example, in the Tenerife case or in the Tokyo Bay case, where the levels of damages were clearly demonstrated to be much, much lower even than Ontario, although it's pretty hard to get much lower than Ontario. In any event, the California courts would not take jurisdiction, and those plaintiffs returned to Ontario and proceeded with their lawsuits. I'll say one word about the thalidomide case because I'm running out of time. I had the pleasure of being involved in most of those cases. There was an early decision in those cases to retain Craig Spangenberg from Cleveland, and he proceeded with them. Contingency fees were a very large feature of that case, and if I could ever say a word about it, that man invested personally over $1 million in that case, starting at a time when there wasn't the foggiest idea as to whether or not there was anything wrong with thalidomide. In any event, the ultimate result of that, as we're all aware, was the recovery of gigantic amounts for the children and, usefully, gigantic fees for the lawyers who were involved as well. Jurisdiction really was no problem. Interestingly enough, the cases were all brought back to Ontario. Lawsuits, dummy in effect, not dummy, but lawsuits, writs were issued in Ontario ultimately after the cases were settled, and all the infant settlements were approved in Ontario and the monies paid in Ontario. One interesting, and I'll finish with this, one interesting problem was the approval by the Ontario court of gigantic contingency fees. Do you know how they worked it out? It was a superb piece of work. If the case was settled for $300,000, it was reported out as $200,000 plus $100,000 costs. That is, the defendant paid $200,000 to the infant and $100,000 to the plaintiff's lawyer. I had one client who objected to, at least raised an issue about the size of the fee. And I remember Don Tracy coming from Cleveland, sitting in my office with this client, and the client just felt that regardless of anything else, the fee was tremendously high, even though it had been a superb result for the child. In fact, the case had been settled for $300, the lawyer's fee was $100. He simply said that they'd settled the case for $200 and his fees of $100 were being paid by the drug company. And frankly, if my clients felt that his fee was too high, he was quite content to reduce it and simply give the money back to the drug company. That was the end of that. They said, oh, all right, they let it go.
Thank you very much, Ken. I think that perhaps one of the messages I meant to convey back to some of my brother judges is that the awards in Ontario courts are not quite what they might be. I'll try to take that message back, Ken. You may have noticed that in dealing with Ken Howie, when you try to settle cases with him, there's always the settlement, and then I always had the feeling in practice that there was the generosity allowance to be added on to any settlement that you had to make with Ken. I see now where it came from. The other thing you might have noticed when he was talking, he indicated that his academic and learned colleagues on his right were going to deal with certain things. When he said that, Buddy Wunder sort of glanced out of the corner of his eye down to me, and I glanced out of the corner of my eye down to Earl. You'll notice that Earl is on the extreme right and there's no one to his right, but he is both academic and learned, and he's now going to deal with his portion of the topic. Earl?
I figured that we were put on this part of the program because we had no academic qualifications, and after reading some of the papers and seeing how good they are, I think they were right to do it. The organizers were right to do it the way that they did. What I thought I could usefully add to this program is some of the experience that I've had in dealing with cases that have this kind of a foreign element, but where one doesn't have the advantages that the kind of committee that Ken Howie and his conferees had in the Air Canada case. The typical case is a products liability case where the injury occurs here, but the manufacturer of the product is in another jurisdiction, usually the United States, or where there's a negligence claim to Ontario residents in a car accident occurs in another province or another state, and the question is where to sue. My remarks and my experience are rather slanted towards using our own jurisdiction when when possible, and I'm going to outline some of the reasons why and perhaps some of the reasons why not. Bill Graham talked about jurisdiction wars. My own view is that this is one kind of war that is much better fought on your own home ground where you know the territory, and there are certain advantages the way that the law has developed here. Some of these considerations that occur to me are first of all, Ontario jurisdiction. Now, as Ken Howard's outlined, the way that our courts have recently interpreted Ontario Rule 25(1)H is that we will accept jurisdiction subject to the question of forum conveniens where some of the damages occurred here. So that gives us, in many cases, the choice of suing here. You have to be very careful when you're considering Ontario vis-a-vis an American jurisdiction or a European jurisdiction as to what the measure of damages is. Now, Ken has given his view of Ontario damages, and I read Professor Fleming's affidavit in that American case. In the 2 years or 3 years since Professor Fleming gave that affidavit, I think Ontario damage law has progressed a long way. And our damage law, I think, in many areas, with a few exceptions, is more liberal than in most American jurisdictions. Maybe some parts of California, some parts of New York and Michigan are different, but in most American jurisdictions and on most headings, I think our damage laws are very liberal, especially in the area of pecuniary general damages, the application of a 2.5% rate dealing with inflation and allowance for productivity. That doesn't exist in most American jurisdictions. And even on the issue of non-pecuniary general damages with our $100,000 limit, there are many, many kinds of injuries where even on that heading, some of the awards in Ontario are more liberal than one would find in many of the United States. So that's a major consideration. Even the question of punitive damages is a very great range in American jurisdictions as to under what circumstances and when and how punitive damages are allowed. And there is a development in Ontario law, in Canadian law, recently, the Robitaille case in British Columbia, and a couple of cases in Ontario demonstrate a trend that even in Ontario law, punitive damages is an expanding field. A lot of your choice will depend on what your theory of liability is. If you've got a case that you can only win on the application of a strict liability theory because you cannot demonstrate negligence, probably the American jurisdiction is the choice because strict liability is not yet a feature of Canadian law. Another consideration is the case that you've got one that is going to be better tried by a jury, because chances are very high that in the United States your case will be tried by a jury. Will the American jurisdiction be an urban or a rural one? Because the level of damages is in many cases very different. I recently had occasion to compare in an aircraft case that I was applying these considerations to, what would be a good idea to sue in Utah, where I thought we could bring the action, or perhaps in California. The opinion that I got from a Utah lawyer in Salt Lake City, a big city there, the level of damages was about half, as Fatal Accidents case, was maybe half of what we could expect in Ontario for the same fatal accidents case, and of course that Utah lawyer wanted a 1/3 contingency fee. So it makes a big difference. What's the quality of the bench and bar in the proposed jurisdictions? How much will a contingency fee be? How long will it take in that American jurisdiction to get to court? What about appeals, if there is one? How long does it take to get there? How many appeals can be brought? if there is a chance for punitive damages, is that punitive damage claim insured? Will it be paid? There's been a number of large punitive damages awards in products liability cases and insurance cases, even in some personal injury cases in the U.S., but I wonder how many have really been paid. The Americans that are subject to those jurisdictions, those awards, appeal them and appeal them and appeal them. I don't think Grimshaw has his money yet. How sure are you that the lawyer that you're going to hire there really knows what he or she is doing? What about the question of interest? Ontario now has a very liberal interest rule, much better than most American jurisdictions. Only British Columbia and Saskatchewan in Canada are better in that area. Another major question is the cost of motions and production and discovery. How is it carried on in the foreign jurisdiction? When you've got this kind of a products liability case, for instance, one of the most important factors is how easy it will be to get the documents dealing with the design and the manufacture and the production of the particular product, which will almost invariably be in the hands of the American defendant rather than in the hands of the Canadian defendant. The Pinot case that I want to talk about shortly is a great example. But one of the most important things in these product liability cases is that you must sue not only in the case of a Ford Pinot, the Canadian Ford company, Ford Canada, who manufactured and sold the Ford Pinot, involved in this case in Canada, but you must sue Ford U.S., who designed the car and made all of the design changes. If you just sue Ford Canada, you'll never get those documents, because Ford Canada had absolutely nothing to do with the design and testing of the Ford Pinot. So you must, in any of these products liability cases, whether it's personal injury or whether it's construction or the like, you must be sure that you bring in the company that actually did the designing of it. And you can be sure that these companies will do everything they can legitimately, usually, to avoid production of these documents, because in these documents that's where the evidence of negligence is often found. The Pinot case is probably an example of what I'm talking about. This was a case where a RCMP officer off duty was a passenger at a Pinot in Windsor, got rear-ended and exploded. The driver got out through the window because the doors were jammed. The passenger didn't. He was burned to death. And the question was whether his widow, who had a child unborn at the time, subsequently born, should sue in Ontario or sue somewhere else. We decided to sue in Ontario for a variety of reasons. One of them was by that time the Julian case had come out. Seemed to be a reasonable opportunity for a high level of damages in Ontario. We sued for punitive damages. Ford defended the action, of course. Ford U.S. And Ford Canada hired a major Toronto law firm that does their work, and they resisted the production and discovery all the way along the line until the criminal charge against them in Indiana was determined. And once that was finally determined, then they became much more interested in giving us the production that we required. They wouldn't let us examine anybody for discovery that knew anything about the case. They gave us the name of some fellow who had a fancy title like design production engineer or something like that. It turned out what he really did was, at the time the Pinot was designed, he was in high school in Dearborn somewhere, but his main job now was to give engineering advice to the litigation lawyers for Ford who were defending the Pinot cases. We wanted a fellow named McDonald, who was the chief engineer of Ford, presently a vice president of Ford, who actually was single-handedly responsible for the design and testing and production of the Pinot. He eventually gave evidence at the Indiana criminal trial, and until he gave that evidence, there was no way that Ford was going to produce them. The point was we were able to make the applications to get these documents and to get him, rather than the fellow that they wanted, in our own jurisdiction in Ontario, and there's only so far that you can appeal those things, and we know what that is. The other interesting aspect of it that turned out to be useful was our discovery rules. We could only examine one person for Ford U.S., but we can ask that one person, and it turned out to be this fellow Harold McDonald, who they finally did to produce. We could ask him anything, and what he didn't know, and he knew a lot of it. And we had these 20 boxes of documents that they gave us on the design of the Pinot. We can ask him anything about any of those documents, and what he didn't know, his lawyer had to undertake to get for us. Contrast that with the American rule, which says you can examine any number of employees or any number of people, but you can only ask them what they know, and you know how much it costs and how much time it takes to examine for discovery 20, 30, 40 people. American lawyers were just amazed at this process. It was very, very useful and saved a lot of time. Anyway, those are some of the considerations that turned out to be useful in that case, resulted eventually in an admission of liability in the Pinot case by Ford, along with an admission by the guy that rear-ended us, and eventually after 5 days of trial in a settlement that was more than satisfactory to the plaintiff. So what I'm trying to point out is that there are many considerations that enter into it, but there are, in my experience, at any rate, very, very considerable advantages in trying to keep the action on your own turf.
Thanks, Earl. We'll now move along and hear from our forum shopper on my left. Buddy, can you help us with your practical experience in this area?
Ladies and gentlemen, this is a confusing area of the law. You're not the only ones that are confused by it. I've read some of the papers and heard the one delivered already, and I think you'll find in your material some really superb treatments of this difficult topic. It's made a little less difficult if you have a choice of jurisdiction. And as Ken Howie admonished you, you ought to firstly learn the limitation period in the foreign jurisdiction in which you're considering litigating it, diarize it, and diarize the Ontario period as well. And then if you can't resolve it immediately, issue in both jurisdictions. So it's a matter of shooting first and thinking later. Now, if in addition to the papers, if you want some help on this subject, there's just a superb book on the market called Lawsuit by Stuart Speiser, S-P-E-I-S-E-R, who handled many multi-jurisdictional lawsuits in which Mr. Howie's named with favor, and the other members of this panel's names are conspicuous by their absence. Wherever I have a choice, now I've heard Earl speak, and Earl is such a convincing speaker and persuasive, and he takes a point that's a position that's diametrically opposed of my own, and now I have some serious doubts about the views that I'm about to advocate. Nonetheless, these have been my practices over the years. It's a blind search for a U.S. connection. And that U.S. connection is often hidden, sometimes I suspect deliberately, in the facts of the case. The advantages that I consider compelling for this American search are these. Number one, in terms of tortious responsibility, the American jurisdictions are still 10 million light years ahead of us. and they will see liability where a Canadian court will not. Except where you've got somebody like Mr. Cherniak at the throttles, developing and exploring and exposing every possible facet of liability and often demonstrating against overwhelming odds. You don't need that kind of lawyer in the States because they have such a much more fertile soil within which to sow your flowers. There are very few insurance company executives on their juries, and hence they are receptive to an argument that has only a scintilla of merit, and if they see a deserving claimant with whom they identify, they will embrace it. So that's number one. Number two, again, Mr. Cherniak is right that we do have a much more sophisticated manner of injury damage determination here that we've developed over the years tortuously in order to circumvent the tenets of the Supreme Court of Canada, where they've put a $100,000 lid and demonstrated that they value pain and suffering so little. The American jurisdictions don't suffer from those restraints, and they don't have to develop all sorts of convoluted arguments on pecuniary and non-pecuniary. They just say, give that poorly injured person the money that he needs. Without a whole lot of damage demonstration. As a result, we've become much more sophisticated in damage demonstration and development in Ontario than the States, just out of necessity. Thirdly, one of the great advantages of an American lawsuit is the contingent fee. So you don't have to sit down with your client and talk about the thousands of dollars that he's going to have to give you to finance your exhaustive investigation into the product liability of the manufacturer. Because the American lawyer is allowed to work on a contingent fee, he becomes an entrepreneur lawyer, and it's worth his while to invest in the lawsuit because the return is often commensurate with the risk. Here, that is not so, and that was never demonstrated more graphically than in the thalidomide cases to which Mr. Howie referred, where the British children had already concluded a settlement, and it was already court-approved and everything until Ken Howie and Craig Spangenberg did their thing and got a super award for these Canadian children, and then all the British settlements had to be reopened because they were so scandalously niggardly. And why? Because the British lawyers were limited in the amount that they could invest in a suit at that time of speculative merit. So there was, and it was solely the contingent fee which the Canadian children were allowed to take advantage in an American suit that worked to the great advantage and exposed the shortcomings of the British system to which we still subscribe. There's a couple of other less compelling bonuses in an American suit, and one is you get paid in American money. It's another 20%, not bad. And finally, you don't have to, once you're successful with your Canadian suit, you don't have to then start another suit in the American jurisdiction where the American tortfeasor lives on the foreign judgment, which itself may subject to whatever defenses are available there. Now, keep in mind my enthusiasm for these principles is somewhat diminished by Mr. Cherniak's remarks, and you certainly can't dismiss what he has to say, and lightly, if at all. Also, you should know that the big jurisdictions for big damage money in the States is limited. They're limited to maybe half a dozen states in which 90% of the U.S. population resides. So you should know that the big states are Florida, California, New York, Pennsylvania, and Michigan. If you're going to get hit or you're going to be subject to a badly engineered product, make sure it was designed in Michigan or California. Now, don't forget your backup Canadian suit in case all of this falls apart. Now, I've learned some good names in the business. When anybody calls our office about an airplane crash, The lady who answers the phone is instructed to say Eric Lane and hang up. For fear we get burdened with the $5,000 deductible on missing the limitation period. And also, it would be useful to you to learn and liaise with an American attorney in whom you repose confidence, so you can call up, like I call my friend in Detroit, Albert, can you handle this? Because there's of any choice, he's absolutely appalled by the cases in which I work so hard and I get so little. And would you believe that Mr. Cherniak and Mr. Howie are on other sides of such cases, and they're defending and trying to resist the claims that I'm asserting for these poor crippled children? I just want you to know who you're dealing with in this panel. Now, just to give you some example of some of the cases where they're hidden, I was consulted about a man who had woodworking at his home, and a tooth of the saw was flung off the saw and entered his eye, and he lost the sight of that eye. Now, here's a case of potential. He was not wearing eye shield or glasses as he was supposed to, but of course that doesn't, contributory negligence is not a defense to an action for breach of warranty. With a little diligence, we learned that the saw was made in the States. And now we've got a lawsuit going over there where he stands to gain much more than he ever will. And in the remote event the lawsuit is unsuccessful, he can work with the American attorney on a contingent fee basis. A U.S. accident is easy. A U.S. car accident, if it's from one of the big states, you just move it on over there. Again, subject to this caveat. We have the best and most comprehensive and most generous insurance coverage in this jurisdiction in North America. And you can afford the premiums because the insurance companies know that the damage awards are subject to the constraints of the Supreme Court of Canada. So they insure for big money over here, but they give much less reward. You got to work a lot harder to get it. So although you may have a super case for big money in Florida, if you can get access to an Ontario policy, possibly under the uninsured provisions, or better yet, the underinsured provisions, which are peculiar to the insured and the members of his family, and not the vehicle in which he was riding or where the accident happened, keep that in mind. You may enjoy that type of coverage, that is big Ontario coverage, on a foreign suit in an American jurisdiction. We have another case that came in recently where one boy went to a gunsmith, a 16-year-old boy went to a gunsmith, and he said, "Sell me some gunpowder." Now, isn't this a fact situation fraught with promise? The gunsmith said, "Oh no, you're too young. I'm not going to sell you gunpowder." He said, "Come back with an 18-year-old who has a gun license. Then I'll sell you the gunpowder." 10 minutes later, he comes back with an 18-year-old friend with a gun license. The two kids are standing there at the counter. The 16-year-old gives him the money. The gunsmith gives him the gunpowder and says, "Now, you know this is very dangerous stuff." That's like a blank check in our type of work, because he knew the danger, and he's telling the kid he knew the danger. And it's the case, you know, that even the most inept plumber would recognize as a strict liability case. So, in any event, 16-year-old comes home to my kid who's only 15, and they're going to make a wick out of Kleenex and gunpowder. And somehow it doesn't light. My kid goes to blow on it, and it blows up in his face. Now, the label of the gunpowder, which had all kinds of warnings on it, reflects that it was manufactured in Pennsylvania. So we know where that suit is going. Direct to Pennsylvania, if I have anything to say about it. Mind you, again, I'm going to have to rethink in view of what Mr. Cherniak comments have had on me. Now, a motor vehicle accident, you watch for the mechanical defect. the tire blowout, the parking gear that keeps flipping into reverse, some design defect, because that, again, will move you to consider an American jurisdiction. And so that, and maybe enhance your client's prospects of getting a much more substantial award. Just going the other way, there's of the papers that you're going to hear, there's two really super ones in addition to what you've already heard by Ms. Block, I believe, on service out of the jurisdiction, and by Mr. Slaght, who deals with security for costs. But foreign plaintiffs coming into Ontario, we have a letter, a form letter in our book that we send right back to the American attorney, Tepaka, just prints out by itself, goes back to him and tells him of all the nightmares for a foreign plaintiff coming here and asking for justice. We start off with security for costs. You mean they've got to put up real money? Well, it's not like it's real money, it's Canadian money, not of anything of lasting value. Up front, so that and then, well, why is that? Well, then we start to tell them about our party system of costs, whereby if you're successful, you get an award, of course, that will recoup you in part for your lawyer's bill, but in the event that you're not, you have to pay the other fellow for having sued him unnecessarily. Well, this often dampens their enthusiasm for litigating in this jurisdiction. I don't want to go on too long about that. I've already exceeded my time, so that's all I have to say. Thank you very much.
Thanks, buddy. I managed to hold back my tears, as I usually do when I hear you talk. Sometimes it's more difficult than others. You can see the practical approach shining through Buddy's comments. Just a couple of things I'd like to pick up on. Perhaps we can get the panel involved for a few moments. Ken, Martin was talking about the likelihood of getting a verdict in Ontario being much higher than in the United States. I think you have some thoughts about defense verdicts of cases that go to trial in some of the American jurisdictions.
Well, there's no question that in the major jurisdictions which have been described, the verdicts are much higher, but if you ever want to study what happens to motor vehicle accident victims or personal injury victims generally, if you want to take a broad look at it, the last figures I saw published, which was about 1977, 70% of the personal injury actions that went to trial in the United States resulted in verdicts for the defense. And we were talking the other night saying we wondered what of the cases that went to trial in Ontario involving personal injury victims, and I appreciate this is quite unsophisticated in terms of a study, but what percentage of those result in verdicts for the plaintiff? And the feeling around the table was in the order of certainly 80%, maybe 80 to 90%, some verdict in favor of the plaintiff. So that I don't think that should be overlooked. One of the problems I've seen is the county jurisdiction situation in the United States. And if you have an accident happening in one of the counties in central Florida, around Immokalee, for example, where the defendant resides there and the case must be handled in that county, it is worse than L'Orignal in terms of the level of damages. So there's an accident happening in Florida, your first reaction might be to go to Florida. Don't kid yourself. I think there are serious problems. I tend to support Earl in this sense. I would prefer, on behalf of a client, an Ontario client, to bring the claim in Ontario if I can justify doing so. That's the way I feel. And if I can't justify doing so for any one of the reasons that have been discussed by Buddy, fine, we consider retaining counsel. Does anybody know a worse situation to be in than to retain a counsel for an outside jurisdiction and then lose complete control of the case? We know now how clients feel about us handling their cases. It's the same feeling.
Thanks,
Dreadful
Ken.
feeling.
Earl, do you agree or disagree with what Kenneth just said?
No, I think that's the approach that I take. If one can keep it here, there's a lot to be said for suing some major American corporation for a poor injured Ontario plaintiff in an Ontario court. It's a very different situation when you've got that Ontario person far from home suing a homegrown corporation down in Orange County, California. It may be quite different.
Could I call on each of the panelists just briefly to give us their ideas as to how they go about referring cases to and from jurisdictions outside Ontario, and what they do when they're asked to handle cases from other lawyers? What do you look out for, and what do you do with protecting your own position from potential liability cases or malpractice actions against you? Let's start off with Ken.
Well, there's nothing wrong, in my view, with arranging that your client should enter into a contingency fee arrangement with a foreign lawyer. That is, if the case is going to be, the action is going to be processed in Michigan, I have no hesitation in having my client agree to enter into a contingency contract with that lawyer. It's improper for me to enter into any such contingency agreement of any kind. In terms of my own fees, there's nothing wrong with me, I suppose, I hope there isn't, recovering in effect for the work which I've done. I'm not even certain that it's improper not to make some contingency arrangement with the lawyer. In effect, I'm not acting for the client, and I'm not certain but don't believe that there's anything improper in that. The reverse situation, one we run into, is the American lawyer, American resident, who retains an American lawyer, who signs them up to a contingency contract and comes to me and says, will you act in Ontario? We have to sue it in Ontario. We want to sue it in Ontario. In that situation, of course, we cannot enter into a contingency contract of any kind, size, shape, or description. And all I do is say I will bill you in due course for my services. And it's got no reference to the contingency contract which you have. My bill will be as if the client had retained me originally in Ontario, with the same kind of arrangement I'd make with the client in Ontario, which wouldn't be a contingency arrangement, by the way.
Buddy, what's your practice? Is it the same? Does it differ?
No, I subscribe to precisely the views that Ken has articulated. And beyond that, you should know that unlike Ontario, where we're all skilled in forensic matters, there's a wide disparity of skills in American lawyers, and there are some, even those that hold themselves out that do litigation exclusively, who are excellent, and there are many who are not so excellent. And you have to ask a few hard questions right at the beginning to find out what type of fellow you're dealing with, because keep in mind the client first consulted you, and if something goes wrong with the lawsuit in the States, your own malpractice policy will likely be on the hook to answer that. So, and you start right off with limitation period, jurisdiction, liability, fees. Those are the hard questions you want to discuss with him and have confirmed by him by letter immediately. And is there any obligation for pre-suit notice? And I know that it's been my sorry task from time to time to advise an American lawyer who's called me that you're much too late. You know, he can't believe we have a 3-month period against suing our government for failure to maintain a road and adequate state of repairs. But we do. And there's no point fudging. You've got to be very direct on these issues, because you don't always know with whom you're dealing.
Earl, do you have anything that you do a little differently from what we've heard?
Well, the major problem is finding the foreign lawyer who is the right foreign lawyer for the case, because you're in the same position that a member of the public is in here who doesn't have any contact with lawyers. You really take your chances, and but the only way that you can do that is either try to get in touch with lawyers who do have a lot of dealings with American lawyers and can find out for you, or spend some time yourself meeting American lawyers at the kinds of conferences where one can meet American lawyers, but it's a very, very difficult problem. Just like to add one thing on this question of American lawyers consulting us. I ran into an interesting situation here where an American lawyer consulted me about an accident that had occurred to some Americans in Canada, and it would have been an ordinary negligence situation, the two Americans in a car, I think it was a one-car accident, and the accident happened in Ontario. And the insurance on that car was very much smaller than the American limits. And the American lawyer was simply amazed when I told him that because that accident happened in Ontario, that car had Ontario minimum limits by the operation of the conventions that applied to that, and not the American limits that he thought he had. He had no idea that that was the case, so that he was actually much better off to bring the action here or insist that wherever it was brought, there were those American limits. So, there's an awful lot of considerations in these cases. Generally, I subscribe to what Ken and Bud have said.
Thanks, Earl. I'm afraid our time is running out. We have other material we'd like to handle with you, but we've got a good program coming up, and if we don't adhere to our time, we're going to ruin the rest of it, and it's good stuff.